Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. Greetings and welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. Well, we've had all kind of things happening, and let me know if you can hear me okay, if you choose to write in the chat. I want to welcome everybody in the bushes and the trees in the Bahamas and Belize, wherever you may be, in the chat. But a lot has been going on with this young thug trial. And it is really, really sad what's happening. And I don't know how many of my people actually look at the young thug trial, but what's been going on is what Judge McAfee called with Bonnie Willis an odor of mendacity. And I say that the prosecutors and the judge in that case is spewing the odor of mendacity. If you saw the thumbnail, I have two pictures of the judge. This judge is a Superior Court judge. As a matter of fact, he's the Chief Justice judge. And he's also a judge for the U.S. Army, the Veterans Affairs. I think he makes decisions on veterans cases, something to that nature. In my opinion, given the history of this judge and the history that I know of, is that he's a brigadier general in the reserves. He has PTSD, and he has a comfort animal for him when he's in the court. And so from what I see of him, I'm thinking that the judge is really confused as to which court he's in when he's in there. Or the judge thinks that he is so smart that he can use the same rules that apply in his veterans court in the Superior Court. I don't have another excuse for it. I really don't. It's really hard for me to fathom that this man has, completed all the things that they say he has done and, rose to the ranks, and he doesn't know the difference between civil contempt and criminal contempt. It's very hard for me to believe that. I showed some videos earlier on some of the things that transpired, and it goes back to day 87. And so I have these videos inside the description if you decide you want to go back and look at them. Days 87, day 88, day 89, this is when all the craziness started happening. And I'm talking about, this is really craziness. And it is amazing to me that our system, which is supposed to be the greatest system in the world, doesn't have a check and balance system to stop craziness from the onset. It just kind of behooves me that doesn't happen. Greetings, Phyllis. Glad you're here. You say greeting, howdy. That is funny. Glad you're here. But it just amazes me how, in all honesty, these people can do what they do and nothing can happen. You know, it feels like, in my mind, and I'm just sitting here looking at TV, imagine the people that are actually in the courtroom. It feels like that you're kidnapped and you have no control over your life. Kind of gives freedom a whole new different meaning, in my opinion. When you see them doing wrong and this man is abusing his authority, and there's nothing you can do, and you have to just sit there and take it. It just goes to show you how they really treat us as people. But I don't know if any of you in here look at Liquid Concrete, but she has some courageous, outstanding videos. And the one she did on this story, it really, really took me by surprise, because she pretty much came from the same thing that I came from. And if you haven't seen it, I will put it in the description. Excuse me. But, you know, she said this man ought to be court-martialed, and he should if he was in the military court. But he's in the superior court, and there has to be checks and balances. And I know that they said there's a qualifying committee or something for judges. They must take a look at this man and see if he's still in the capacity to hold his position as a judge. And I don't know, with him having stress as an issue with PTSD, I don't know what it comes from, but it seems to me that this is a little too stressful for him. But then when you look at the shenanigans that he's pulling along with the prosecutors, then, you know, you can say, well, no matter what state a person's mind goes to, they always seem to have the mindset to cheat or to mistreat. And that's disheartening. It all started back on Friday, the 7th of June, when Kenneth Copeland was supposed to testify. Now, the state has built their whole case around this Kenneth Copeland. And now I'm beginning to believe that, as conniving as they are, and seeing how Fonnie Willis get down, this is all the plan. And we're just seeing it play out. And had things not played out the way they are playing out, then they probably could have fooled us all. But if you look at what happened, this young man's been in trouble all his life. He said he's been in jail in and out so much he can't even count. And then he said he was in jail in 2012, 2013, 2014, 2015. He went to feds. He got out in 2019. And I don't know, maybe he's been out since then. He said he was in special ed classes. He says he has problem with his eyesight and his hearing. Perhaps he's telling the truth. Perhaps he's not. I don't know. But for his reputation to be what it is, it seems like this is the perfect person to use to do what you're trying to do. And what you're trying to do, if you're Fonnie Willis, is to come up with as many RICO cases as you can, so that you can get as many millions as you can to spend, and don't have to answer to anybody. And that's what's really disconcerting. And it seems like the people in Georgia are not concerned about it. But they may not be. People everywhere should be concerned with all of the craziness that's going on today in what we call the government. If we study and learn the Constitution and realize the First Amendment to the Constitution give us the right to petition our government. We don't have to take everything that's going on. We just take it because we believe we don't have another way. They have all these policies and procedures and laws and guidelines written, but nobody reads them, or nobody wants to read them. But sometimes there is a time in your life when you need to read them. They have what they call canons of law, the old canons. And the Canon 2 is for judges. And then every state has its own canon. Willis said people are not concerned about nothing until it happens to them. Yeah, that's so very true. That's so very true. And what amazes me how most people aren't interested in truth unless, like you said, it happens to them. It's really strange. And it would really get me, I don't know, maybe it's my thumbnails, maybe it's my titles, but it's amazing how people can be telling the same story, talking about the same thing, and they get hundreds of people in their chat, and I don't get 10. And I know I'm saying what people need to hear. But maybe that's the problem, because a lot of people say they come here for entertainment. I be looking in other people's chat as I'm watching their video, because I don't just look at their chat, I look at their video. And I be reading their chat, and a lot of people be saying, this is so pitiful, but it's entertaining. How is this entertaining? It's really not entertaining. It's sad, and it should be a learning experience. But I guess people see entertainment differently, because I don't see any of this as entertainment. I see it as knowledge. And I wish people would take notes, because you never know. It's them today. It could be you this evening. And people said, read, they say if you want to hide something, put it in a book. Well, put it in writing is what you wrote. Yeah, but even in writing today, you can listen to the book. You don't even have to read it. You can just buy the audio. And they even have readers on YouTube for a lot of the books that you might like. They have them here. Nobody cares about the power of knowledge, and that's so sad. But I'm going to keep on doing what I do, because one day somebody is going to need this. Okay, and the Canon 2 for judges in Georgia Code, it says impartiality and fairness. 2.2. This is what judges are supposed to be. This man is so biased, and he's so biased till when he's referring to the state, he referred to them as we and us. And that really irritates me. I know that he is the jurist, and the state is the prosecutor, as they call him. But for him to put them together every time he speaks of the state, it makes you think that he also worked for the state. And therefore he would be looking for the same outcome. He says we so much. It's really, really troublesome. But the rules for the judges to be fair, promptly, and efficiently. That's how they're supposed to be in their matters. And this is just something that I'm showing you, because I'm not going to read that. I'm going to read some of it, but not this. This is just what I wanted to share. The Georgia Code for judges, 2.3. This is for biases and prejudice and harassment. And I swear, to me, this judge is very, very harsh to the European attorneys in this case. Although I've heard him speak very, very rudely to Mr. Matthews as well. And that's very sad to me. How he never lets the defense finish a sentence. He cuts them off, and they're supposed to be able to speak an entire sentence so that they can get the matter on the record. But he doesn't allow them to do that. And that's really sad. It says, bias, prejudice, and harassment. Judges shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, or harassment based upon age, disability, ethnicity, gender, or sex, marital status, national origin, political affiliation, race, religion, sexual orientation, or socioeconomic status. Judges shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. Judges shall require lawyers in proceedings before the court to refrain from manifesting bias or prejudice or engaging in harassment based upon attributes including, but not limited to, age, disability, ethnicity, gender, or sex, marital status, national origin, political affiliation, race, religion, sexual orientation, or socioeconomic status against parties, witnesses, lawyers, or others. The rules does not preclude legitimate advocacy when those things, all of that I just named, or other similar factors or issues in the proceedings. Judges must refrain from speech, gestures, or other conduct that could reasonably be perceived as prejudiced or biased or as harassment, and must require the same standard of conduct of others subject to their direction and control. And so we see how it is with the bias of a judge. Then we go on to 2.9. 2.9 is very important in this situation because it speaks to ex parte conversations. Ex parte just means one side. And unfortunately, on Monday, day 88, the judge allowed an ex parte conversation to exist between, and the judge is what would make it ex parte, because you can't talk to the judge without the other party knowing that you're talking to the judge. But I'm going to go back to Friday when Mr. Copeland pulled the switcheroo on them. Mr. Copeland's attorney was present for that when he went to go on trial. The problem came is I think he interpreted the judge saying, even though we gave you immunity, you have to testify. And he said, can he say what he want to say? And he said he's got to tell it. So he said, well, he said I could tell it. And he may not have said, can he say what he want to say? He may have just asked him a question and he said that he could tell it. So he, I believe, interpreted that to mean he could say, I plead the fifth. Maybe he didn't, but that's just what my mind tells me. And it tells me that because he knew the way she started off asking him questions, and I thought this was strange, but as I stated the other day, now I believe it was contrived. I believe that she picked that. What is your age? So that when they go to argue, that he didn't answer any questions that would mess with the case. I think they knew that it was a plan. And I also believe that they possibly met with the judge on Friday. And I don't know if he was in attendance, but I believe that the prosecutor did, and maybe it was just Miss Love, but I believe it was Fonnie Willis as well. Nobody would not make me believe that she hasn't been a part of all of this. And maybe she has not. That's just my belief. These people are playing awfully dirty, and they do this all over the United States in all courtrooms. And they do this because the people won't arm themselves with knowledge. And we take everything they say as being the gospel truth. Because we think because we're paying them that they're going to do what they say they're going to do. But a lot of people talk a lot of good game. And they talk integrity and honor. And there are people that really have integrity and honor. So you have to trust your own intuition as to how and you're going to trust the person with your life. But these people here, they have shown nothing but, to me, disdain for honor, truth, and integrity. I swear they seem like they're enemies to those things. But I believe they had a conversation on Friday, because I recall Miss Love telling the judge that she wanted to have an ex parte conversation. And then when I was looking at Phil Holloway, attorney Rachel on there, she said that she heard it too. So it's a possibility that's when they started concocting all of this. And then Monday, when they brought him, then they took him immediately into chambers, because they brought him, apparently they brought him, I guess, a couple of hours before they were doing court, because they started like 2 hours late. So go figure. And perhaps they did that so that they would make sure he would be there on time. I don't know. Peter said these folks are ruthless. Yes, they are. Talk is cheap, I was told. Audio, that takes up their time for foolishness. Well, I guess you got a point there. I guess you got a point. But this was amended through April 15, 2024. And the rule is 2.9, assuring fair hearings and averting ex parte communications. A, judges shall accord to every person who has a legal interest in a proceeding or the person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending, proceeding, or impending matter, subject to the following exceptions. And then they give the exceptions as to when you can do that. And I highlighted, the judges reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communications, and the judges makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. This judge didn't do that. He came in from the ex parte secret meeting and held court. They have commentary, and in the commentary it says, judges shall immediately stop an attempted improper ex parte communication. B, does not excuse of judge from this ethical requirement. Number 2, the right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Well, this judge don't believe they have the right to be heard, because he told Mr. Steele, when he held him in contempt, criminal by the way, that he didn't have a right to a hearing. And a superseders appeal he could not make. Well, I have proof that you can make the appeal. He made the appeal, and today the Georgia Supreme Court granted him the appeal. See, there are rules and procedures no matter what people believe or what people think. There really are. And it's been a lot of good, shenanigans, and maybe that's what people call entertainment, because you see the state lying and getting caught in their lies. But that's pathetic. It's really sad, because these people's lives are on the line. And then, people say, well, they're criminals. Well, everybody is presumed innocent until proven guilty. Everybody. Number 3 says, see Rules 2.7 and 2.9c, addressing limits on the scope of evidence that may be legitimately considered by the court. And the evidence is just out the yin-yang in this case. I mean, you never know. I know that they have a rule of evidence, and then they have a time period where discovery is supposed to be made. But I swear these people do new stuff every time we're in court. They come up with some new stuff. Hey, yes. Good to see you. Glad you stopped by. We're having a great hump day. I'm humping. Number 4. In recent years, jurisdictions in Georgia have created what are often called therapeutic problem solving or accountability courts, including drug courts, mental health courts, and veterans courts. So in those courts, and maybe that's where he is in veterans court. Maybe he's not doing it for, and maybe it is for the military, but they said in Georgia they've done this. So, but I know he used to go to veterans court. And in those situations, what they're saying is that you possibly could have ex parte conversations in those given situations. But, you're dealing with certain circumstances, but you can only have those kind of conversations when the law allows. And then here we go. We're talking about contempt. The Georgia Code 1513. Powers of the courts generally. This judge thinks because he asks you a question, hey, Moonchild Pink, good to see you. This judge thinks because he asks you a question, that's an order. And that's not an order. But it says here, powers of the courts generally, every court has power to preserve and enforce order in its immediate presence and as near thereto as is necessary, to prevent interruption, disturbance, or hindrance in its proceedings. Number 2, to enforce order before a person or body empowered to conduct a judicial investigation under its authority. Number 3, to compel obedience to its judgments, orders, and process, and to the orders of a judge out of court in an action or proceeding therein. Number 4, to control in the furtherance of justice the conduct of its officers and all other persons connected with a judicial proceeding before it, in every matter appertaining thereto. Number 5, to administer oaths in an action or proceeding pending therein in all other cases when it may be necessary in the exercise of its powers and duties. Number 6, to amend and control its process or orders so as to make them conformable to law and justice, and to amend its own records so as to make them, let me see, because I had to switch over screens. Amend its own records so as to make them conform to the truth, and to correct its own proceedings before final judgment. That's what this 15:1-3 says generally. Georgia 15:1-4, we're going to talk the extent of contempt power, because he was interchanging the contempt powers. He was saying that he was doing a criminal contempt, but he was trying to hold him to the civil punishment, which the civil punishment of a contempt is, I'm trying to compel you to do something. So I want you to do something. If you don't do it, then I can put you in jail until they use the word, you purge yourself of that punishment, meaning until you do what I ask you to do. Excuse me. Criminal contempt is not that way. It's punishment. So if you have a criminal contempt, I have to actually give you a punishment, and the most I can give you is 20 days and $1,000 fine by Georgia's law. Hey, so Alicia, good to see you. It is really good to see you. Hope all is going well. But what he wants to do is, he actually told an attorney, an outstanding attorney. I'm going to do a video about Mr. Steele and his wife, because his wife is an attorney as well. And as a matter of fact, as this judge was acting like he was, I don't know who he thought he was, but while he was acting out in the courtroom, she was drafting up the appeal. When she saw her husband have to take off his coat and tie and walk to the back room under arrest, a man who practiced throughout the United States, a man who has been in the appeals, he's tried 300 appeal cases, and a couple, I was told, was overturned by Judge Glanville. So he acts like he has a bias, which he's not supposed to have. I know we're human, and so is he. But when you have a profession, you have to do everything in your power as an adult to take the emotions out and do the job, get the job done. And you should be just and fair. His wife, I'm told, was successful in winning a RICO case, meaning she stopped whoever it was from trying to put the RICO on the people. So they're astute attorneys. They know their job. Mr. Steele is truly a hero. You know, he's been saying he's willing to put his barcode up. He's willing to put his life. And he's like that for every client, he says. And he was willing to do that for Jeffrey Williams, Young Thug. And he was willing to do what the law requires him to do. And you know, that's just like on any other job. If you work on a job and your boss tell you to do something wrong or illegal, you do not have to perform that act. You know, some people say you can perform it because your job. No. Don't do that. Because before you know it, you will look up and you will think that, of course, that's what's going on. But I promise you, they will swear they don't know anything you're talking about. Nothing. So I would advise you to never do that. I don't care who it is. If they tell you to do something wrong, don't do it. Just don't do it. You got to be willing to stand for something or fall for anything. There has to be something you believe in so much that you're willing to die for it. And it has to be you. Because you have to live with you. You have to face you. And if you can do that with you, you'll do that in any situation where you know that right needs to prevail. See, what Mr. Steele and his wife and the Honorable Ashley Merchant believes in is the Constitution. Something that we refuse to read and learn. But we all should be enforcing the Constitution. We all should be. Life would be much different if we did. I started doing a series before I started covering this trial right about the same time. And that's the trial penalty, which was the Sixth Amendment, which is something they're trying to get everybody away from. They want everybody taking plea deals. But no, you're giving up a right. And those that have a right and do not use it, is better off without the right. And when I say it's better off, I don't mean you're a better situation, better condition. I mean, no better for you when people don't give you that right. You have to let people know that you know. Because everybody is not integral. I don't care what title they hold. Everybody is not honest. Everybody is not kind. And you know by their actions, by their behavior. You will know a tree by the fruit that it bears. You're not going to see no orange fall from no apple tree. Or no plum from a peach tree. You're just not going to get that. And you don't know which peach is sweet until you bite into it. But you can tell the ones that are rotten. And you don't have to do that. You don't have to bite into it. But Georgia Code on extent to contempt power is A, the powers of the several courts to issue attachments and inflict summary punishment for contempt of court shall extend only to cases of misbehavior of any person or persons in the presence of such courts or so near thereto as to obstruct the administration of justice. Number 2, misbehavior of any of the officers of the courts in their official transactions. Number 3, disobedience or resistance by any officer of the court's party, jury, witness, or other person or persons to any lawful writ, process, order, rule, decree, or command of the courts. And see, what this judge didn't do, he didn't order Mr. Steele. He didn't give him a writ. He didn't decree it. He didn't command it. He just asked him. And then Mr. Steele told him, under the code of 106, under professional responsibility, he couldn't answer his question without violating the privilege. But because he was giving him a punishment for criminal, he was entitled to a hearing, and he asked for the hearing through his lawyer when she came, Ashley Merchant. But the judge wouldn't grant the hearing. I showed y'all those videos the other day. Then I wanted to share, and I'm going to share a little bit of those videos because I want y'all to see just how this started, because this is so unfair. When Mr. Melnick, who is the attorney for Mr. Copeland, the witness who wanted to take the fifth, the prosecutors are so dirty. They probably had access to attorneys' calendars. It's some system that they have to put their vacation requests and stuff in, just like you do on a public job. So I don't know how the access is to it, but for them to have to put it on the calendar and to go through the court to do it, who they have to go through, because I don't know the procedure. I'm not an attorney, nor do I practice law or give legal advice. I read law, and I give my understanding of what I read. But whatever it is, he had already done that because it's been on the calendar since December of 2023. And he told them that. And it's amazing how when he said that about his tickets, how both Miss Love and Miss Hilton, it was like they was doing a dance move. They both leaned back in their chair and crossed their legs and looked like, child, please. It's some hanky-panky stuff going on around here. You know, Liquid Concrete always talk about the boule and all of these people that are in these sororities and fraternities. And you know, we were told that they all came about to help each other because of discrimination, and we could never get jobs and never get ahead. But it is amazing to me how it seems, and it's just my personal opinion, because I know people in sororities and fraternities and other societies. But it just seems like it's a status, just like the 1% over the 99. And it seems like that they kind of look down on those that are not. And it's amazing how people that look like me, Asiatic, they don't even know who they are, but they'd rather be Greek. It's amazing to me. But one thing you learn, and the higher up you go, the more knowledge you get. It's called degrees. So it's according to your degree, according to what you really know. And some know the truth, and they shun and stick their nose up at us. Judge Glanville is Alpha. Miss Hilton is a Delta. I believe I read Miss Love is AKA. Don't quote me on that. Bonnie Willis is a misfit. She wanted to be an AKA, but she didn't make it across the line. So she's in their sister chapter, according to the research of Liquid. And Liquid does some hell of a research, and she shows you as she do it. So you want to check out all of her videos. She told the very first man, Prince Hall, that was given a lodge, and it was under like a military style. She's deep, and she really breaks it down, and she shares it, uncut and raw. I just did a little research on these people, and especially after the infamous sign that everybody now has captured. The first person I seen that brought it to the public's attention was Seti Nash, but people on X probably was bringing it out, but he was the first one that I seen on YouTube that brought it to the public's attention. And I thought that was really strange when I saw that shenanigan going on, because, you know, they're doing some talking, and I'm sure those attorneys, they're sitting there and they're looking and they're paying attention, and all they don't catch, their interns catch. Hey, Regina, it's good to see you. Phyllis said, well, if the fruit is planted, you might see a corrupt tree, okay? You will see a corrupt tree. Moonchild Pink says, speaking truth, 100. Phyllis say, now you know what it is meant by the saying, you must stand if you have to stand by yourself. And oftentimes what you need to prepare yourself for is that's who you're going to be standing with. You. Everybody talk a good game, and everybody want to fight as long as you leading. But when it gets to standing, you're pretty much going to be standing by yourself. But I want to show y'all the clip. I clipped it. Of this infamous signal that everybody's talking about on X. I finally got on X. I don't know how to post. I was able to send something there, and I don't know if it was my whole video or not, but I was able to send something there. But I want y'all to see well, I'm going to set it up for you. The judge said something to the bailiff, and then the bailiff left out, and then here's when the bailiff came back. You all will see what happened. And you know, they have all of these signs and stuff, but you know, they don't want you, they can't share with everything. Everything is such a secret. Everything is a secret. They can't share, they can't tell, they can't talk, they can't know. It's just too much, to be real honest. But I want y'all to see this. And I just need you all to look at the judge and look at Miss Hilton. Now, I don't know what the communication was, but it was definitely nonverbal communication. It's kind of like, I don't know if y'all have, well, everybody at some point in their life has been in a church house, perhaps. And you know, the ushers, they have their little signs, and the pastor, and he has the little thing he does, and all the important people in the church know what it is when he do whatever it is he does. That language that's unspoken, but yet is spoken before the whole masses, and nobody really knows what's being said. Regina said, my apologies for being late, but trust I have been keeping up with the case and all the shenanigans. The judge got to go. Yeah, he's going to be going. He think he's not, but you can tell he's a little worried. You can tell today he's really worried, especially when he got served that paper from Mr. Weinstein. And I have that document. I'm going to share that. That's why I'm not going to share a lot of videos tonight. I want to read some of these documents. And like I said, it's amazing how I see other people giving these same stories. And in a minute, they have hundreds of people flocking in there. And it's just amazing. We only get 3 or 4, but it's okay. All I can do is keep doing my show. But what do y'all think about that nonverbal communication? Because it's the talk of YouTube. But I know that they're both boule. So I know that it means something. What the something is, I can't tell you what it is. But trust me, it has a meaning. A significant meaning. I don't know what day this is. I have the days that I've been, things that I want to kind of show y'all so y'all can really understand what's going on. I also want to make an announcement. There was another case going on in Georgia in another county, and it was young Hispanic lady, 16 years old, and she's a young girl, not a lady. And one of their police officers, and from what I heard, I think today he was like 23, unalived her. And so he had a trial that started, seemed like last week, and it was over today. The jury deliberated and they were gone, looks like a minute. I don't know how long they were gone, but they came back and the judge imposed a life without the possibility of parole on that unaliving charge. And then there was another charge he had. She gave him, the most she could give him according to the law was 12 months, and she's running it consecutive with his life without parole. So that means he'll never see the light of day outside of that sentence, possibly prison. And they used the excuse that he was adopted. And that's probably really not an excuse, but that reason is just not good enough. There are many, many, many adopted people that are not going around doing what he did. And he chose to be a policeman. So he was adopted when he chose to be a policeman as well. So I don't understand when people play those cards. And there's so many cards today you can play, because everybody's playing them. And it's so sad. Everybody's playing the game. Okay, there's day 88. Day 89. I want to go back to day 87. Because I want y'all to know, I saw some stuff I thought I would never see in life. when I seen when I seen when I seen the judge allow a man. Okay, wait a minute, that's coming on. I don't want that on. I don't know why that's on. Okay, it's gone. Yeah, I don't want that playing. When I seen the judge allow a man, now this is game, y'all. I want y'all to know this. Let me just explain this. The lady that came to be with Mr. Copeland on Monday, that young lady was just a stand-in because the attorney had already had plans and he could not change the plans. He said that he had these tickets since December and it had already been put in. And had the prosecutors contacted him like they should have, then they would have known this and he wouldn't have been put in this precarious situation. But of course the judge blamed him. And that's so unfortunate how this judge is so very prejudicial. It's just the odor of mendacity all over the place. It's really sad. But be that as it may, I wanted to show y'all how this got started because the man told them that he was the attorney. And it should have been already there that he was the attorney of record. He was the last known attorney anyway. You know, if you don't do nothing else, you could go with he was the last known attorney. But did they go with that? Nope, not them. Not that group. That group said, forget about who you think you are. You need to be who we say you are. So what ended up happening is this lady was standing in for him. She was only going to be there that morning because all he was supposed to do was plead the fifth. But what ended up happening is they scared him so that he fired her. So he fired her while they was in the room. They just made her come in there so they can say that his attorney was present. And then they called him in the courtroom and say, guess what? She wants to be released. She's asking to be released. We got to make it on the record. She's asking to be released. Mr. Copeland, do you want to release her? And he gets on there talking about she fired. And she's saying, Your Honor, I'm trying to tell you. But Your Honor kept cutting her off. He never lets them complete a sentence to put things on the record. And when a judge or anyone interrupt you when you're speaking, one thing about a good lawyer, you got to be able to take it right back to that same conversation, that same sentence, and get it on the record. Because if you don't get it on the record, it is not preserved for an appeal. You can't add anything new in the appeal. Not if you're the person that's appealing. Now, the other side might be able to do that, but they're not going to let you do it. I guarantee it. Regina said, oh, I just heard about that case with the policeman and the teenager. I thought she was 19 years old. I caught some of the interrogation of him on YouTube. I'm still confused as to why he did it. Zip up the back. He was zip up the back. Yeah, he really didn't have no reason to do that. Yeah, so we go. I'm looking for day 87. And this is what's so very sad, that they did this to this young woman, but they think that they really doing something because, see, the judge said he wasn't going to even have no show cause hearing. But when Ashley Merchant marched in there on him, he changed his whole tune. He changed his whole attitude. You know that moment when you know that you've messed up? And you wish probably your day hadn't started the way it started that morning? I want to go so I can take y'all to what happened so we can see I have this little stuff written down, but I have to make sure. But it's the right video. I'll be sitting here going through all this writing and doing all of that. And by the time I get with y'all, I'll be just as confused as the day is long. And the judge been sick ever since I've been looking at this case. He been coughing, sneezing. And when he was coughing, Kenneth Copeland was leaning all, looking all funny. That was so funny. Like the judge was coughing on him. I'm just going through this video. I'm not that good, so I don't know how to edit where I can get it right where I want it and all that good stuff. I'd love to be able to do that, but I just can't do it. So let's start here. Let's start here, y'all. I just want to show y'all we gotta get a visual. And I showed this the other day, but it's really, we need to see it today, so.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial,
And that Mr. Melnick is with us now, and that Mr. Copeland is outside, correct?
No, he's in.
Okay. Say again?
He's here.
Okay, all right. All right, Mr. Melnick, good morning, sir. Welcome.
Good morning, Your Honor.
All right. Sir, do you have any issues of concern or that I need to take up before the state calls your client?
I do, Your Honor.
Okay, go ahead.
May I approach?
You may.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrienne Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yeah.
Let me respond for a moment. Now, this man is telling the judge that these people knew that he was his attorney during the time that he had issues. And he was his attorney for this situation because he was always going to be his attorney for this specific situation. I'm going to point it out again. I want you all to listen to what she believed. And that doesn't work in law. It doesn't work like that. But I want you all to hear what she believed and the story she's about to give. And how the judge goes along with it.
All right. And Mr. Malik, you are correct. I did go ahead and sign this morning. I'll make a part of the record. The court's order giving him use immunity. Okay.
Just to be honest, I don't see how the court's honor of use immunity could be in effect when he didn't listen or the prosecutors didn't negotiate with his attorney. They just offered him that because they want this case against Young Thug that bad. And it's going to show that it is so terrible that even the guilty people are walking free. And that's why, if they were after gangs, why are all the gang members out on plea deals and Young Thug and the guys that are left here that's fighting for their freedom are all in jail with no bonds? It's amazing.
Good morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Gary. I would believe.
What does that have to do? Let's cut to the chase. Okay?
So
I mean, all of that it may be maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right. So I'll let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Gary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, we have not spoken to Mr. Copeland previously when he had open pending cases. We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or if Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was.
Now she's believing everything, and she believed her understanding of all this is her belief.
Was that he hadn't spoke to him or that he wasn't his attorney. At that point, we continued to engage in conversation. Mr. Copeland engaged with us. On Monday, we reached out to Mr. Copeland to see if he wanted to come down to do witness prep. We did not meet on Monday. On Tuesday, we thought that he was going to get called. He came down here. We spoke. He asked us questions. We answered his questions, and we've moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case.
So she can talk to him because he's a witness in her case and they were having good conversation to her belief.
Yesterday at our final prep session, we spoke with him. It was about 1:00 in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Max Shard in the hallway. As we left, we had our greetings. And then it was not until 6:00 last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the fifth. In the state's conversations with Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to testify in the trial. Once we received the.
So listen to all the wrongdoing these people say they're doing. He didn't have use immunity before she got that email. They came in Friday morning with the use immunity. They gave him the use immunity after his attorney told him he was going to plead the fifth. The use immunity compels him to testify. But they did that after the fact. And the judge signed off on it knowing that it was after the fact. So the judge is very complicit in this corruption. Now, I don't know if they allow him to do this kind of stuff in Veterans Court, but perhaps he should stick to Veterans Court. And I don't know what all he covers in Veterans Court. But he is definitely going from honor to dishonor in this court because he's breaking a lot of the professional rules of conduct for judges and attorneys. So he still has to live by those rules. Let's keep going.
The email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. 24-5-507, Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Melnick. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Coming up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter?
Now, did y'all notice the judge told him he didn't need to be sworn in yet? Why is that not something that he would need to swear to under the penalties of perjury?
Letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I need 2 copies of it. Actually, 3.
You're fine.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposed order.
But I signed the order this morning.
I meant the manner in which it will be filed will not be made public.
Okay. All right.
She said the post order, and Joanna said, but I haven't signed it. Oh, I meant. Boy, right in the courtroom.
Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that?
Generally, whenever you get something of that nature, it's a contract and you have to have your signature on it. So they would have had to give him a letter for him to sign in order for them to ask for an order. Wonder where is that copy?
All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnotes, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. And the state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness.
He caught himself because he used we a lot when he's speaking about the state. And you see, he looked up at the ceiling. Judge Judy always teach you those kind of body language signs with the eyes. Because he said we, and then he said get you to come to court, as if he's talking about the judiciary. But there are several times in his conversations when he's referring to the state, he referred to himself as a part of the state by saying we. I just want to point that out. These are little things that we, as lay people, need to understand should not be going on. And if you don't know how and what to say, and what you hear, if you don't know how to stop it from being said, then you're in a world of trouble.
Witness, they determined that their testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. and I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you're taking the fifth, but you've got immunity, but you still want to. Are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then.
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but
Like Mr. Copeland know what he's talking about, machinations and intricacies. Mr. Copeland saying, I may be ignorant, but I'm not stupid. And the judge is playing him real stupid, in my opinion.
Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways. Like you testify and use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you'll tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him.
That's
So
right.
I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. I will formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potential.
Ask my attorney before, because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick? Come on up, Mr. Copeland. All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So, are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right. What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir. Go ahead and stand outside, please, if you wouldn't mind. We'll call you in just a minute. right, Mr. Melnick, I wanted you to be here for the this part of the conversation in regards to your client, because these are prior convictions, okay? All right.
Your Honor, Mr. Copeland has a total of convictions that I believe should not come in are as follows. 09 SC 82479, which was a September 1st, 2009 conviction.
Your Honor, Mr. Melvin has been gone for about 30 to 35 minutes.
Can we call him, please? Or tell him that we are going to need him back?
This is the part where she's talking about, he's talking to Miss Hilton, because he's telling them he's going to plead the fifth, is what he's telling them.
We can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KENNETHCOPELAND.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, for
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question, so.
Know how the judge said we didn't know what he was going to say. We didn't know, and he just let him ask one question. He was only asked one question. But like I said, that one question was purposeful, and they had planned that one question to be his age. That's what they wanted, so that when they come back with, well, he wasn't asked any questions that was germane to the case. Oh, this is really a snaky snake.
At this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew.
Now, the court is litigating the case. It's not based on the last thing he knew. When you hear of something that is supposed to happen that can disrupt this case, I read those rules, then you should let the court know immediately. And Mr. Steele does this every time and get admonished and even punished for following the law. Not what the judge's preference and his cronies, but the law. So let's just hear this play out.
And he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So.
the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everybody. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland.
Now let's listen to all of this conjecture and speculation and what she thinks. I just want y'all to hear this on the record. This is what he's allowing. He don't let the defense finish a sentence on the record. But listen to this that she's about to give.
As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So could you sit down at that time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down and I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then
now, is she saying his attorney is not supposed to be present when he speak with the state? She said his Mr. Melnick keep walking in. How many times can he walk in with a client?
as
Does he at any point in time tell you? Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you.
Now the question becomes, the $6 million question becomes, how about the $13 million question becomes? Who did they learn it from? The judge wasn't concerned that they learned something that they wasn't a party to. Like he's going to be so upset about that ex parte meeting. Just keep listening. They learned that Mr. Melnick said they were not in the room. They learned. So who did they learn it from?
So Miss Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify.
My point exactly, Regina. See, the thing of it is, Bonnie Willis and her unscrupulous ways has unscrupulous staff members that's willing to do whatever they can, because now I believe love is vying for Fonnie's job. Fonnie may think she's telling her by any means necessary. She doesn't understand what that means to this pariah. And she's corrupting Hilton, who may already be corrupt with her condescending tone. I just can't stand it. But they're at odds. You can see them bucking heads. But they're going to be in unison when this man say that he has unrefundable tickets. Non-refundable tickets, I should say, instead of unrefundable. It's non-refundable. But I want y'all to just check these moments out. He's talking about all this body language and all of this well, that's what you say when you say non-verbal. But she didn't use the word body language. I don't really want to be like those people. I try to stay as close to the truth as possible. I may not always get to mirror what you said correctly, but I'm going to try to keep it to what you said and not what I'm interjecting, as they're doing. But let's hear this.
So watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question
he's not facing any state charges. But Mr. Copeland knows his record, and he knows what's at stake. He does not want to be locked up, for sure. But his behavior has dictated what's going to happen to him. Currently, he's not under any charges, but there's that issue that he had and could have with the feds. They know that, he knows that, his lawyer knows that, and that's why he wants to take the fifth. But they don't care about this young man's freedom, because all they want is gang, 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 but they let the gangs go free and incarcerate the innocent. And those that are locked up can't even get an indictment. And if they get an indictment, they can't even get a public defender. And people think this is entertainment. These are atrocities and tyranny that's happening in Atlanta. And the world should be concerned. Well, now the world knows about this case more than ever because of this judge's behavior. And he should be disbarred. He should be dishonorably discharged. He should be whatever they were trying to do to young Thug. It should happen to these people in this courtroom that know this is a bogus RICO case. Let me get back.
whose interests he's representing. And so we would ask that, I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland, because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him.
So she says she don't give a what about him having an attorney. They will continue to break the professional codes of conduct and speak with this man without his attorney. As long as he will speak to him and they can intimidate him, then they will continue to do that. Keep listening.
I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are. Because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that I guess the state's going to hammer him. I don't even know what, but
the judge haven't asked her not one time, where did she get that from? You're accusing another form of judiciary of saying something that is not true. Where did you get that from? How are you privy to that conversation? Because I thought attorney and client conversations are privileged. But the judge didn't open his mouth. Listen to this craziness.
Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it. And I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this, but there's a great investigator who is looking at me and I trust her. I'd like to call her as a witness. I was told I was not there. I was told that, I forget her name. I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up, and then the Honorable David Bobby. The Honorable David Botts told me as I was walking in that he heard, he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
so
I'm going to remind it all the time because I live them. I'm just telling the court that in order for you to deny my motion for a this was bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time. Okay. In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you're saying.
I'm not going to call any witnesses. I don't need any witnesses. Your proffers are fine. Okay.
Can I add a proffer, Your Honor?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach. And I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. My belief, agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making a...
How do you know it was on the phone? If Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was
okay, but
no interaction with.
Okay, but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this was going to
Okay, all right, but all of you have kind of, like I said, either unwittingly or I just remind you from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So
the defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is state.
I didn't say you did anything wrong, but
I understand, okay, Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I don't
know of any counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer. And that lawyer can make that decision, and so can Mr. Copeland. So
situation because
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay?
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Malnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case. Speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal. I
don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right.
Notice how this tyrant allows this lady Love to talk without interruption. But these people can't complete a sentence and he's breaking in. This is all to disrupt the record. He don't want them to have this stuff on the record for appeal. He thinks he's slick. Like I said, I wanted to name this, is he confused? Does he think he's in Veterans Court as opposed to Superior Court? But I don't know. I really don't. Well, I do have an idea. I don't know. But when I look at all the millions that these people are getting, and they don't have to account for them to nobody. The commissioners give them this money. They say they're constitutional officers, and they change how they spend the money once they get it. And they're getting millions that's unaccounted for. They all need to be under a DOJ investigation, a real DOJ, and they need a forensic audit of all of their offices and their budgets. He's the Chief Justice of Superior Court acting like this. And I wonder, how did he get this case? I just wonder how. It reminds me of going back to the Boule. These people, they get these positions, they get these titles, and not all. So do understand, I'm not talking about all. I have nieces, nephews, cousins, friends that are members of these societies. But I'm talking about those that are at the top, that have reached the degrees, that know the truth, that are messing over the masses so that they can live like massa. This is totally unacceptable. And we as a people allow this to happen. There are things we can do. The Constitution gives us the right to petition our government. But these people are acting government because there's no way. There is no checks and balances nowhere. And everybody's running amok. But we're held to every standard that they pretend that they uphold. Cry me a river. Let's keep going.
You're right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons.
Now the witness ain't no good. This is the witness they gave full immunity to. Immunity.
About his testimony. He has expressed those this morning. He said, I'm going to invoke my Fifth Amendment privilege. The state came to me and said, okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So,
but his attorney should have known about it. They just did that this morning. After he sent them an email telling them yesterday evening he was his attorney. And this judge is just going along with it like they ain't never said any of that.
So there are, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you, I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that as you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland. About Mr.
Now he's questioning the man's honor and integrity. He's calling him a lie, really. He doesn't think they would do that to him. They did it. He just told him the last time he communicated. He has emails. This judge is just ridiculous, and all that placating and patronizing is utterly ridiculous.
Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness first.
I'm going to point it out again. Now listen how strong she's talking. When she was talking before, she believed he wasn't. It was her belief. They didn't mention the attorney. Now listen to what she's saying. She now has all of this authority in her voice.
because
When
my
did you talk to
understanding-
Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays, when we picked him up for the first time, on Tuesday, when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home. And then yesterday, he came back down here with us. Again, we showed him some of the evidence that we were going to show him. And that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney. And Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But, whether or not...
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So
Now that's how angry they sound. And all that body language. And why is she standing up next to that man with that too little skirt on that she keep pulling down? This makes no sense. And that's a dress with a zipper up the back. It's just ridiculous. These people are utterly shameful.
I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules, okay?
Of course.
And that sometimes has to be explained to witnesses and clients, okay? All right. So that's where we are at this point in time, is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up. Because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Now, if Ms. Hilton says she told her that he wasn't the attorney, why would they have to rely on what Mr. Copeland said? And if Ms. Hilton is the one that's investigating this witness, then why wouldn't, if that's what the lady told her, she not do her own due diligence and check with the attorney for her own self's sake and for her own ethics that she swore under oath to uphold? These people don't know, I guess they don't care, but they took an oath to uphold the Constitution of the United States as well as the Constitution of the state in which they reside, which is Georgia. And in all constitutions, there is a clause. It's 14th Amendment in the U.S. And it says that you have the right to due process. And the 6th Amendment in the U.S. says you have a right to a fair trial before a jury of your peers. These people are breaking all constitutional rights, and he has a 5th Amendment right not to incriminate himself. Not just if you're in a state court, because there are two different jurisdictions. So this is just horrible. And I wish every parent with a child would be looking at this video and other videos. We've got to get more people interested in what's happening to us. We always complaining about what is done to us and how the immigrants are taking over and getting all the benefits. Well, they have advocates for them, and those people learn the rules, the policies, and then they do what it takes. All we do is complain and pray, and one day the Lord gonna get us out. You got to become the Lord of your life, and you got to learn the rules of the world, and then you got to make them work by participating. You've got to complain just like you compliment. You cannot allow this to happen, but we allow it every day. And all we do is complain.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland.
If you talk to Mr. Copeland, he knows he's his attorney. He just said he was going to put it on record. But this man is ridiculous. And I want y'all to check these two women out. Check out their body language when he say he has tickets that are non-refundable. Please check them out.
Like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay. I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, this is one of those times as a lawyer that you're gonna probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Joe. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you are, you have put us in a situation where now you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
Then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll have somebody go.
And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right. And I'm going to go ahead and at this point in time, summon our jurors, please. All right.
Okay, I've been talking to you guys without my mic. But the court was supposed to go ahead and on Monday he was going to call him in and let him plead the fifth. So the lady that the attorney got, she was just there just to go in there for him to plead the fifth. Unfortunately, things didn't happen like that, and we've heard the big fallout about it, and we've seen that he was put an order out for Mr. Steele to go to jail and the guy to be free. So I'm on X now, and I was able to see some of the documents, and I never knew how great it was to be on X, but I tell y'all, it's some good information out there, and I'm learning. So Mr. Steele again is married to a lawyer, and so she did an appeal, as Ashley Merchant told the judge that they were going to do. They were going to do an appeal. And he like, whatever y'all want to do. He didn't care. He thought he didn't care. But I think they changed his mind. So I want to share some of that information with you guys. I don't need day 87 anymore. I want to share some of that information that I have with you guys. Let me see what I have here first. I think I'm going to start last, because that's the juicy stuff. I did was, this guy, he's called Thugger, and he has a page, and he's really good, and he puts out a lot of information on the post, but he covers this story. He does a lot of good research. He's really good, and he has a lot of the information and documents. But Mr. Steele was telling the judge that he could not give out the information because of attorney-client privilege. Now, what we learned, as Mr. Steele educated us, that attorney-client privilege doesn't just go with conversation. It goes with your work product. And that means anything or anybody that helps you learn knowledge to help your case. So, here you go. The principle of confidentiality is given effect in two related bodies of law: the attorney-client privilege, which includes the work product doctrine in the law of evidence, and the rule of confidentiality established in professional ethics. The attorney-client privilege applies to judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. Not because the judge say I'm entitled to know, and you better tell me. He's not the law, he's just the judge. See also scope. The requirement of maintaining confidentiality of information gained in a professional relationship applies to government lawyers who may disagree with the client's policy goals. So, it applies to everybody. And then I just kind of highlighted 24 at the beginning. It says, a lawyer should make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to the information covered by this rule. A lawyer should make reasonable efforts to safeguard information relating to the representation of a client against unauthorized access by third parties and against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. See 1151. Okay, so that's that. Now remember, he told Mr. Steele if he didn't tell him and Mr. Steele didn't tell him, he was going to hold him in contempt. And he did. He held him in contempt. And let me go to the next document. So while he was holding him in contempt, 25 to 40 other lawyers came down to support Mr. Steele. Now, you can't even get 25 family members to come nowhere with you, let alone 25 to 40 esteemed attorneys who came from the strike force. And what they do is, Ashley Merchant is the president of the defenders attorneys. They have this association. She's the president. And then within that, they have what they call the strike force. And it's a group of attorneys that no matter where you are, if you call and need help, they're coming. They're coming to represent you and to do what they need to do to help you through whatever you're going through. So his wife was busy while this was going on. And this is, I'm just going to read the little that I have, one page, because I want to read the real document, which is the one the judge got handed today that had him so discombobulated he had to end court early. He can say what he wants, but we know he was very upset, because he was upset now that he has to do that show cause hearing. But here you go. Very interesting stuff. In Court of Appeals of Georgia, State of Georgia, Brian Steele Movement. Emergency motion for superseders bond on criminal contempt. Because what he did is he sentenced him to the 20 days after Ashley Merchant educated him on the difference in criminal and civil contempt, because the judge was totally confused. And as she said, he wanted to take the best from both worlds, but that didn't work. It says, come now movement, Brian Steele, hereinafter Mr. Steele, by and through undersigned counsel, and files this emergency motion for superseders bond on criminal contempt pursuant to Court of Appeals Rule 40B. In support of this emergency motion, Mr. Steele shows the following. Mr. Steele is lead attorney of record for Jeffrey Williams in State of Georgia v. Jeffrey Williams, ETAL. Indictment number. A 65-count RICO indictment charged 28 individuals. The jury trial of multiple defendants commenced in November 2023 before Fulton County Superior Court Judge Glanville. The trial is expected to last through the end of 2024 calendar year. And there we're going to stop, because that's all I got of that. And we're going to go to the next document. I need y'all to understand how crazy this is. Fonnie Willis and that woman, Love, ran for DA in 2020 on gang violence. They were going to get the gangs put away. But it was 28 people, but now it's only down to, in this side, 6. The about 9 or 10 of them, they gave plea deals. So some say they're crazy deals because of the time that they're going to have to be under the plea. But what matters is that they let these people go free. And these are the people that did some of the most heinous crimes. It's amazing how things happen in this country. But they were fighting to take the gangs off the street, they said. Okay, so here we go. I got to get to that good document. It is juicy. I keep hitting the wrong thing. Okay, so they filed that superseders bond, and it had to go to the Supreme Court. And on today, the superseders bond was granted. So he does not have to go to jail. So the judge ought to feel real stupid right about now. And I'm sure he did, because he was a little thrown off today. Excuse me. And I want to thank again Thugger and Joseph Pep. They're on X. That's where I got the information from. And I want to thank Kat Not Williams. I went into her. She's very good in covering this. Very good, very knowledgeable. And she told us about Joseph Pep. So I want to thank them and let them know that I really appreciate the help they've given me. It's some fantastic people covering this story. There's a lady, Nell Gooseby. She says, I'm not a lawyer, but she's very, very good too. Seti Nash is good. Infamous Sylvia. These people, Eban Film, these people, they give their own take. And sometimes I don't always agree with their takes, but they're good at what they do. And what's really good is their editing. These people about to make me at 65 try to learn how to edit, and I don't even like computers. But that's what's really good. And Melanie King, of course. One moment. Okay, thank you for waiting. The Supreme Court of Georgia, and they gave the case number, June 12, 2024. The Honorable Supreme Court met pursuant to adjournment. The following order was passed. In re, Brian Steele. Movement Brian Steele appealed to the Court of Appeals a trial court's order holding him in criminal contempt. At the same time, he filed in the Court of Appeals an emergency motion for superseders bond on criminal contempt. The Court of Appeals transferred that emergency motion to this court, citing State v. Murray, and they gave all of the information. And nothing that we have the ultimate responsibility, and noting that we have the ultimate responsibility for determining whether this court has appellate jurisdiction over the matter. Pretermitting whether the emergency motion for superseders or the related appeal fall within the court's jurisdiction over murder cases, compare e.g. Gillum v. State, and they give the numbers. We hereby grant a writ of certiorari as to both the emergency motion and the appeal of the contempt order. See Georgia, and then it tells you that's Georgia Constitution, 1983, and that's article, there it is. When the appeal of the contempt order is docketed in the Court of Appeals, the Court of Appeals is directed to transfer that appeal and record to the court. We further grant superseders with respect to the trial court's order holding Steele in criminal contempt. And they give the reason why with the article, the Georgia Constitution. And then they go on to tell that number 7, the Supreme Court rule number 9, as a result, enforcement of the trial court's order is stayed pending resolution of the appeal. All justices concur except Peterson, PJ, not participating. So he was the only one who didn't concur because he wasn't participating. And I don't know how many justices that they have. So, now that we've heard that, let's go to the good stuff. So now one of the things that they said that took place in that meeting is that they were going to let the witness go for testifying because he would have satisfied the contempt, civil contempt that they gave him. So that was one of the things that was supposed to have been said in that ex parte meeting. So here it is. Now they let the criminal go and then arrested the attorney. And you just tell me how that works. Only in America. Bahira says the judge also interlaces his fingers under his chin. And the raising one finger, yes, one or two times while looking at prosecution. That's right. I think that is a signal. It is. Everything they're doing is a signal. I'm going to show you. Did you see the signal where he did with the ear? And she did it with her ear? I'm going to show y'all that again before we go off. But I want to read my little stuff because, you know, time passes so fast when you're having fun. Judge Glanville yelled at YSL grandpa. Yes, he did, Attorney Botts, for not telling about Woody, when Steele had just told him. He is racist toward, I believe he is too, toward European attorneys. He's very, in my opinion, he's not racist because he doesn't have the power to be racist. He doesn't own nothing, but he's definitely prejudiced. For the social construct of white supremacy, racism, you have to be able to control a person's entire life, not just their freedom. You have to be able to control their education, their health care, their nutrition, and we don't have that. Their police departments, we don't have that. You can get mad at me all day. I can get mad at them all day. Any black person or any white person, as people like to call themselves, but we are not colors. We are actually human beings, born into a human family. Our identity was stolen. But the thing of it is, until you can control the 9 areas that Mr. Neely Fuller came up with, and that is education, entertainment. No, I got to say it alphabetically. That's the way I can kind of remember it. Economics, education, entertainment, and I got to think of the rest. These are the things that you have to control. When you control these 9 areas of life, and then I'm going to come out of order because I can't remember them all. I just can remember some of them right now. Law, politics, sex, and war. So it's about 3 of them that I missed in the middle. But unless you control all of those things, and none of us do, so we don't have the power to be racist, but we can definitely be prejudiced. And most of us are. It is unfortunate how he treats them because he talked to them so bad, in my opinion. But it just goes to show you it doesn't matter who's sitting in the position of power, because it's been that way ever since it's been colonization of the United States, and they took over our identity and our land. And we've been subservient to them. And when we get in the position that we claim we want to be so that we can make it better for our people, what do? We get there and do the same thing. So, is it really about race when it's only one, and that's the human race? It's about power and status. It's sad. But let's look at this. Look at what he signed. In the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams, ETAL. Order to release witness from custody of the Fulton County Jail. Order to release material witness from custody. On June 7, 2024, Kenneth Copeland was arrested pursuant to OCGA 245507. After this court held Mr. Copeland in contempt of court for refusing to testify after being properly subpoenaed to testify, being granted immunity, and being ordered by the court pursuant to OCGA 245507 to testify. The court finds that said witness satisfactorily purged himself of contempt of court by testifying on Monday, June 10, 2024. The witness is currently under direct examination by the state. Said witness being currently in the custody of the Fulton County Sheriff, and said witness having satisfactorily purged himself of the contempt of the court, it is hereby ordered that upon receipt of this order, the Fulton County Sheriff will instantly, I can't see that word, let me see if I can see it over here. He got the Fulton County Sheriff will instanter release. Instanter, I never heard of that. Maybe that's the word I need to look up. Release said witness from the custody of the Fulton County Sheriff. Further, it is ordered that said witness Kenneth Copeland shall remain subject to the order of the court pursuant to OCGA 245507, signed by this court on June 7, 2024, and said witness shall appear and testify before this court until said witness is released from the subpoena by the court. And that was so ordered on the 10th of June 2024 is when he signed it. Okay. If that's not good enough, let's get to the good part. This is the order holding Mr. Steele in contempt. I want to see if I can make this a little bigger. But I don't want to make it so big I can't read it. Okay, now this is what he did to the Honorable Mr. Steele, the lawyer. Amazing, y'all. This stuff is really amazing. Order to release material witness from custody. I did that. And this is Mr. Steele. Order of contempt and incarceration for Brian Steele. During the proceeding in the above styled case on the afternoon of June 10, 2024, one of two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. That is what's wrong. That is what's a violation of the rule. But that's not his issue, not the judge's. The judge's issue says the only parties present for this ex parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, who was under oath, and counsel for Mr. Copeland. And that's the stand-in. And she was only supposed to be there for him to say he was going to plead the fifth. But this is who was in the conversation. In addition to the court's serious concerns with how the information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience in its order and to control the conduct of persons connected with a judicial proceeding. The only difference is he didn't have an order. And just because a judge asks you a question doesn't mean it's an order. He didn't say he ordered him. In rear, and that's the name of a person in Georgia, and that's the case law he gave. Before a person may be held in contempt for violating a court order, the order should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be expressed rather than implied. The question of whether a contempt has occurred is for the trial court, and its determination will be overturned only if there has been a gross abuse of discretion. Once an act has been determined to constitute contempt of court, the action the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. But the judge didn't know that when he was trying to impose such a harsh sentence against Mr. Steele. He didn't understand what he was doing. He was trying to get the best of both worlds. And then it gives the case law on direct summary criminal contempt, which arises in the presence of the court and tends to scandalize it and hinder or obstruct the orderly process of the administration of justice, the preservation of order and decorum in the court, etc., is exempt from the due process requirements of notice and hearing. That's what he thought. Little did he know he was wrong. And then he gave a case law. Accordingly, it is hereby ordered that pursuant to the court's authority under, and he gives the statute, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. Anytime you're being charged with a criminal charge, and I am not an attorney, I don't practice law, but I read it, and I've heard lawyers say it, but I've read this. Anytime that you are hit with any type of criminal questioning, you have a right to have a lawyer present. It's called Miranda. You should be read your Miranda rights before you're arrested. And the right should tell you you have the right to have an attorney present before you answer anything or say anything else. You have that right. And he had a right to a bond. He had a right, the same rights that you have when you're accused of hitting somebody upside the head, assault. It's the same thing. So a court can't just tell you, just because I'm the court, I say what go. No, that's not your position. It is further ordered that Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail, 901 Rice Street, and then he said at 7 p.m. on Fridays, and will be released at 7 p.m. on Sundays. Mr. Steele's incarceration is to start this Friday, June 14th, 2024 at 7 p.m. and it is not to end until Sunday, August 18th, 2024 at 7 p.m., subject to further order of the court. And he signed it as an honorable judge. How is that honor? He's always reminding the defense of their professionalism, and Mr. Steele is one of the most professional people in that courtroom. All the defense attorneys appear to be very respectful, very honorable. Now, these are some posts that I got off of X, and I'm going to read these, and then we're going to read the document that Mr. Weinstein filed that really had the judge discombobulated today. He had the judge very upset. Okay, I hope everybody in here has hit the like button. Consider becoming a member. Consider giving a Cash App or a Super Chat. I put in a lot of work to bring this information. I do it because I love it. But YouTube has a way for us to make money, and I really would love to make money as well. But if I don't, I don't. But I just want to remind you that I do have Super Chats. I do have a Cash App. And I do have membership. And I would appreciate members. It really helps keep the channel going, especially with my monthly charges and everything. Again, I do this because I love it. So I won't stop because I don't have those things. But I would be lying to anybody if I told you that I didn't want those things, because I saw this for me as a second stream of income. It hasn't worked out that way so far, but I do have some people that do give, and I appreciate you very much. Very much. They love my work, and I appreciate that. Now, this was done by Andrew Fleischman, and Joseph reposted it on X. Rule number 4, attorney's appearance withdrawal and duties. Rule number 4.1, prohibition on ex parte communications. Except as authorized by law or by rule, judges should neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Now let me tell y'all why I believe the judge is so upset. Because of the things that were done. They keep accusing the judges, and I believe that Miss Love and the other lady, what's her name, Miss Hilton, they're saying that lady was in there and she could have been the only one. She had to be the only one. I don't know if it was her. I don't know who it was. But I can tell you this, some of the stuff that they were saying and doing is truly, truly going to bring this case to an end. It cannot go forward with this group of people. It's not going to be able to do it. Okay. This of note, an exhibit or post that Joseph made. And he said, of note in the exhibit, it is believed that at the meeting that the following happened. Copeland told Glanville at the meeting that he would plead the fifth again and would not testify. Copeland stated that he would rather sit in jail for 2 years than testify. That's what he told them. And he really meant that. That's why he cut his hair before he came in there. And he did a post on IG saying he's getting ready to go to jail. So all this that they're saying he was so ready to talk, they're lying. That young man was not ready to do that. Of note in the exhibit, it is believed that at the meeting that the following happened. Now remember, all of this is on X. So this is not a legal document, but we will hear from the legal document in just a moment. Glanville told Copeland that he would keep him in jail until the other defendants were tried. They are threatening this man under coercion, under duress. This man is afraid for his life from them, not from anybody on the street. ADAs told Copeland that there were still 12 defendants left to try. Following the above coercive action by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, Copeland stated at the ex parte meeting that he would testify, the documents state. Of note in the exhibit, it is believed that at the meeting that the following happened. And see, at times the lawyer was in there and at times the lawyer was not. And just because the judge and them saying they're going to make the transcripts available first, he said he wasn't going to do it. It'll happen on appeal. But I don't know. I hope they don't start tampering with the transcripts and stuff. Because really, they're in trouble. Glanville presented Copeland with printouts of the perjury statute and the false statement statute of the state of Georgia. Copeland told Hilton that he would lie if he is called to testify. This is the man they let go free, and the attorney for Young Thug, the judge locked up, who didn't really go to jail, but he had the order to go to jail, so he was locked up. Of note in the exhibit, it is believed that at the meeting that the following happened. Hilton said she won't prosecute Copeland if he lied on the stand. Did you hear what I just said? Hilton said she won't prosecute Copeland if he lied on the stand. Copeland allegedly said to Hilton that he would state that he killed Donovan Thomas. Of note in the exhibit, it is believed that at the meeting that the following happened, Hilton said she won't prosecute Copeland if he lied on the stand. Oh, I just read that. I put that on there twice. I didn't realize that. Hilton allegedly said she would, listen to this, y'all. Hilton allegedly said she would prosecute Copeland for perjury if he stated that he killed Thomas. She said she would prosecute him for perjury if he said that he did. Now, that's all of that. Let's get to the real document. Mr. Weinstein handed the judge a document today, and the judge looked awfully perplexed when he got this document. So here we go, y'all. I don't know. I'm getting to that slurred speech stage. I don't know what the world is going on, but we're going to try to make it work. Let me stop sharing this and start sharing the other. Have y'all ever heard of that song, When We Gonna Get to the Good Part? Right down to the good part. All right, on. Well, we finna get down to the good part. Trust me on this one. Open your ears, because you're about to hear some stuff. Unbelievable. But this is how our sons and daughters are railroaded every day in courts all over. And trust me, when I say our sons and daughters, it mainly happened to Asiatics, but trust me, it happened to all ethnicities. This world is based on, from what my opinion is, classism. And they see us as useless eaters. We shouldn't even be here. And so, how will we get rid of them? We enslave them again. We make them slaves. How can you make them slaves in 2024? Commit a crime. Incarcerate them. According to the 13th Amendment of the Constitution. Now, this is what Mr. Weinstein filed today, y'all. And this took the judge. It knocked him off his square, I can tell you that. In the Superior Court of Fulton County, State of Georgia, versus DeMonte Kendrick, and Mr. Weinstein is his attorney. And this is what he sent into the Superior Court, and he filed it. So this is not just conjecture. This is an accusation that he's making fully to the court. The defendant, Mr. DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion of recuse Chief Judge Earl Glanville from continuing to preside over the present case and request that the present trial be temporarily halted until the present motion is heard by another judge of this Superior Court, consistent with the uniform rules of the Superior Courts of the State of Georgia, stating the following. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that a court should be fair and impartial. And he gives the case law. And he omitted the citation. The present case involves a 65-count RICO indictment against 28 individuals. Jury selection in this case began in January 2023, with a jury trial beginning in November 2023. Given that the state has presented less than half of its current witness list, which the state has announced could be increased based on circumstances, the trial should last well into 2025. The 6 defendants presently on trial, including Mr. Kendrick, have been denied bond and incarcerated for over 2 years. How fair is that? And the man who said that he actually did this, he said he did it. And they said, I'll prosecute you for lying if you say that. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. On Friday, June 7, 2024, Kenneth Copeland was sworn in, despite being warned by Chief Judge Earl Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity. Copeland refused to testify on that day. And it's very important that he said that he was sworn in, because being a sworn in witness, he definitely should not have been a part of any ex parte conversation with the state, the judge, the court reporter, and the young lady that was standing in, who tried to tell the judge that he fired her, so she wasn't his attorney. He couldn't represent him. He told her he didn't want her and he fired her. But he did that, I'm sure, because he was afraid of what they had threatened him with. That's just my personal opinion. Nobody told me that. I'm guessing like everybody else. See Exhibit 1, Weinstein Affidavit. Copeland was ordered incarcerated by Chief Judge Glanville on that date. And Chief Judge Glanville, and they need to know this is the Chief Judge acting like this. Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Now remember that Friday, his attorney and Copeland said he was going to take the fifth. On Monday, June 10, 2024, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m. Admitted interest into courtroom 1C and seated within by 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Attorney Brian Steele, counsel for the defendant, Mr. Williams, inquired with the court as to the delay and what had occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. Unknown to any member of defense counsel, during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Chief Judge Earl Glanville's chamber on June 10, 2024, among Chief Judge Earl Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. No member of defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. Upon information and belief, neither Chief Judge Glanville nor any member of court staff nor the Fulton County DA office made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. And they did not. Copeland briefly testified prior to a lunch recess. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and made aware of at least some of the content and subject matter of the ex parte meeting. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in the chambers of Chief Judge Glanville. Sworn witness. He's not just a man off the streets. He was under oath. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. This young man really does not want to testify. And he's doing it more or less to protect himself, as we all would if we had a record like his. So let's not play like he's really a horrible, terrible person. He's not. He's doing what we all would do. Just like those young men are paying their life savings, their family's life savings, I'm sure. Not theirs. Some of them have money. Thug is the most with the money. But one or two of them may have a little money because they were rappers as well. But I'm sure their families really had to come together. And I should say their families really had to come together to help them out. But let's keep going. Upon information and belief, Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief, Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. Upon information and belief, Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he unalived, Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he unalived Thomas. I honestly don't understand why we can't use words that are indicative to what's really going on and that are germane to a story that we're telling as we're reporting the news. It is not like we sitting up here just singing this word. And I guess if we were singing it, we could use it. But I think it's just really sad that we can't just read. We have to remember, or we could be defunded from getting our video monetized. And trust me, every little thing helps when you're monetized. Every 1 or 2 people looking at your video for however long they choose to look, it really helps. During court on the afternoon of June 10th, 2024, when one or more of the above allegations were presented to the court by Attorney Steele, Chief Judge Glanville denied that one or more events above relayed to him were accurate. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. And he gave the case law. The present motion for a recusal is being timely submitted to the court. The present motion is being filed and presented to the court in a timely manner. Uniform Superior Court Rule 25 governs motion for recusal. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge not later than 5 days after the affiant learns of the alleged grounds of disqualification. USCR 25:1. Such submissions shall be submitted not later than 10 days prior to the hearing or trial which is the subject of recusal, unless good cause is shown for failure to meet the time requirements. Given that the most recent incident demanding recusal just occurred on June 10th, 2024, a 2-day period elapsing from the incident requiring recusal to the filing of the present motion is good cause. The present motion includes a sufficient affidavit demonstrating the need for recusal. An accompanying affidavit by Douglas Weinstein, Exhibit 1, Weinstein Affidavit, with evidence for recusal has been filed and is now presented, which fully asserts facts upon which this motion is founded as required by USCR 25:1. A review of the Weinstein Affidavit shows that it is clearly states facts and reasons for the belief that bias or prejudice exists, as is required by USCR 25.2. The Weinstein Affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality. These glasses, my eyes, and the glare on this computer is really something. Okay, he has a footnote. USCR 25:1 also reads that in no event shall the motion be allowed to delay the trial or proceeding, and this motion will address the internal conflict between USCR 25.1 and 25.3 in a later position of this motion. Let me go back up some. Went down a little too far. Present cause. As required by USCR 25.2, the particulars of the Weinstein Affidavit are provided above and need not be presented again here in detail, but lays out alleged allegations of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in the chambers of Chief Judge Glanville on June 10, 2024. Recusal is warranted based on the facts alleged in the Weinstein Affidavit. The facts. The facts alleged in the Weinstein Affidavit must be assumed to be true when deciding whether recusal would be warranted. See USCR 25.3. The details learned by Weinstein upon information and belief detail the holding of an improper ex parte hearing with the footnote conducted with sworn witness Copeland which violated the constitutional and statutory rights of Kendrick, including the right to due process and a fair trial. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.93 of the Georgia Code of Judicial Conduct. And then the footnote, the second one, is Uniform Superior Court Rule 4.1 generally prohibits ex parte communications. And I read that a moment ago. So that's that. And 2.9, I read that earlier, which assures every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communications are presumed to have been in error. And then he gave the case law. Rule 2.1, I think that's point 11A. In the revised Georgia Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. And boy, is his questioned in this action from what I've seen. Followed by a non-exclusive list of specific situations in which recusal is required. And we have them all on video. That's the good thing about them allowing cameras into the courtrooms now. See, this is the year of revealing, and from on out, nothing will be in secret anymore. Just look at everybody in every walk of life who's being uncovered. And these are the people that hold us to the highest of standards. You should hold yourself to the highest of standards. You don't owe it to anybody but yourself. The people you're trusting probably don't even trust you. So if you are true to you, you'll be true to everybody you meet. The standard is an objective one, and he gives the case law and where it is. The facts must be considered from the perspective of a reasonable person rather than from the perception of interested parties or their lawyers' advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. And the law is done on a reasonable person's theory. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. And then he gives case law. Let me stop, because at the end of that case law, he says, as the Georgia Supreme Court wrote, we need not, quote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she, end quote, has a personal bias or prejudice concerning a party or a party's lawyer, quote, ended. And then they give the case law. Defendants were not provided notice of the hearing, either before, during, or after. Regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness is a critical stage, footnote 4, of the trial is being coerced to testify. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the sworn witness into testifying. That's the only thing you can conclude. The footnote 5 says judges may initiate, permit, or consider ex parte communication when authorized by law to do so. I read that already too. So we know if the law allows them to do it, they can do it. Given the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient, and that recusal would be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all requirements of USCR 25.1, 25.2, and 25.3, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse Mr. Kendrick's request that the court make specific factual findings and submits that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Let me clear my throat. One moment. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all requirements, and I just read that. And I read that. Should the court take neither of the above actions, I read this, but I'm going to start here. Mr. Kendrick moves that court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review. And he asked the judge for that today because the judge is supposed to have stopped, but he didn't. And he said that that wasn't required. Go figure. I think that when he's practicing in this superior court, he really thinks he's in veterans court. And he thinks that all of the rules don't apply the same. And so he did the footnote for 5 down here. And here is 4, critical stage, is one in which a defendant's right may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Let me give you the case law. During the course of a trial, there appears to be an internal inconsistency between Rule 25.1, which mandates that a motion for recusal shall not delay the trial, and Rule 25.3, which mandates that the judge temporarily cease to act upon the merits of the matter. Mr. Kendrick submits that the court can reconcile the intent of these rules by briefly hearing the motion to determine the timeliness and sufficiency of the Weinstein affidavit and make the necessary determination without delaying the trial. The court regularly hears motions during the course of the present trial, and this motion is no different. And then it is this 12th day of June. And it has the attorneys. Rule nisi. Wherefore, the defendant having filed a motion to recuse in the above captioned matter. And as he's asking the judge to sign that. And he gave the certificate of service where he served them all. And this is his affidavit, his sworn affidavit. Weinstein affidavit in support of motion. Personally appeared before the undersigned officer duly authorized to administer oaths. Douglas S. Weinstein, who upon being duly sworn deposes and states the following under oath and penalty of perjury. Number 1, sworn witness Kenneth Copeland had been held in civil contempt of court on June 7, 2024 for refusing to testify on that date after being given a grant of immunity by Chief Judge Glanville, who is presiding over the present case. Number 2, Chief Judge Glanville instructed the witness and all parties on June 7, 2024 that Copeland would be jailed and returned to court on June 10, 2024 at 8:30 a.m. where he would announce whether he was prepared to testify. Number 3, upon information and belief, defense counsel were all present in the courthouse at 8:30 a.m. on June 10th. Number 4, defense counsel were all present in courtroom 1C by 9 a.m. on June 10th, 2024. Number 5, upon information and belief, an ex parte meeting was held in Chief Judge Earl Glanville's chamber on June 10, 2024, among Chief Judge Earl Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. Number 6, no member of defense counsel for any of the defendants in the present case was present at the ex parte meeting. Number 7, upon information and belief, no member of the defense counsel was aware of the ex parte meeting before or while the meeting was taking place. Number 8, sometime between 11 a.m. and 11:30 a.m. on June 10, 2024, Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Number 9, at that time, Attorney Steele, counsel for Mr. Williams, inquired with the court as to what had occurred prior to Chief Judge Glanville taking the bench, and his inquiry was not accepted. Number 10, Copeland briefly testified prior to a lunch recess on June 10, 2024. Number 11, upon information and belief, at the ex parte meeting the morning of June 10, 2024, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Number 12, upon information and belief, at the ex parte meeting the morning of June 10, 2024, Copeland stated that he would sit in jail for 2 years rather than testify. Number 13, upon information and belief, at the ex parte meeting the morning of June 10, 2024, Chief Judge Glanville informed Copeland that Chief Judge Glanville would keep Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. 14, upon information and belief, at the ex parte meeting the morning of June 10, 2024, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Number 15, upon information and belief, following the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, Copeland stated at the ex parte meeting that he would testify. Upon information and belief, Chief Judge Glanville also presented Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, on the morning of June 10, 2024, in Chief Judge Glanville chambers, Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, on the morning of June 10, 2024, in Chief Judge Glanville's chambers, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute Copeland if he were to lie on the stand. 19. Upon information and belief, on the morning of June 10, 2024, in Chief Judge Glanville's chambers, Copeland also stated to ADA Hilton that he would state that he unalived Donovan Thomas Jr. On number 20, upon information and belief, on the morning of June 10, 2024, in Chief Judge Glanville's chambers, in response to Copeland stating to ADA Hilton that he would state that he unalived Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he unalived Thomas. 21. During court on the afternoon of June 10, 2024, when one or more of the above allegations were presented to the court, Chief Judge Glanville denied that the one or more events above relayed to him were accurate. Further affiant saith not. And that is his affidavit. So, they have to have a hearing because what Judge Glanville did is he went ahead and set what they call a cause hearing, a show cause hearing. And he did that because the attorney, Miss Bumpus, wanted to be released from the case, but what she was asking the judge in open court, and I have those days in the description, starting from day 87, 88, and 89. Those are the days when all of this craziness took place. But of course, you can go to 90 because every day it's been something crazy or weird going on. But I just wish that we as a people would start educating ourselves. We cannot rely on anybody else to educate us. We can't even rely on anybody to actually represent us if we don't know what they're talking about. So what we have to do is we ourselves, we have to learn. We may not know everything, but we have to learn whatever it is that we can so that when we hear them talking, then we'll know somewhat about what they're talking about. We don't have to know it all. We just have to know. And it's very important that we start getting interested. So a lot of people look at these trials and stuff for entertainment, but I would submit to you to look at them for knowledge, take notes, look up some of those statutes and stuff. When you hear them talking about things, just look them up in your, leisure. When you're just on your phone playing games or whatever, just ask Google, what does this statute mean? Or pull up this statute. Or if you hear a word that is used constantly in the courtroom that you don't use all the time, ask what the legal definition of that word is, because they speak a different language than us, even though it's the same words. And the drama, I guess it means something to somebody, but to those family members and the people that are going through it, this stuff is very painful and it hurts. And we can see how they've been railroading our children day after day. Just think about all of those people, no matter their guilt or innocence, because again, you are presumed innocent until proven guilty. But just think about all those people that are incarcerated that they haven't even been indicted. They don't have public defenders. And these people in these positions are getting millions of dollars in the name of making programs and helping these individuals. Preventative. They say they were all about the gangs, but if you remember, Miss Timpson said as soon as Fonnie came, she abolished the gang unit that helped the children in gangs. She took that away. She bragged about being the only DA in the public schools. What is she there for, to arrest the children? Because she doesn't have a program in all schools. I don't know about all over the United States, but in the Dallas Independent School District and the districts around us, all of them have officers in the schools now that assist. So I don't understand. She's the only one with a DA in the schools. What are you doing? Locking them up? You know, because they have quite a few children that they lock up and try as adults. Bahar said she is lying and he knows it, and allow the use immunity argument in court. Corruption. They worked on the plea deals the same corrupt way. Yeah, well, you know, I see them as, you know, following the leader. And we know Fonnie Willis is their leader. And she can't get away from this. There's so many stories that I be wanting to tell, but my mind be running and racing. And I don't know how to just do a little bit because there's so many. I see people take this story and break it up so many different ways. And I love what these people do. There's no need of me lying. I really do. I just don't have that kind of talent. But I love what they do. And the talent that I have, it is mine and I own it and I am proud of it. So we all do what we do. But it is really, really, really good. I wish the public would come and hear my version sometimes. And perhaps they will. You know, the lady who just went to prison for stealing $15 million, the one that gave Fonnie Willis a $1,000 donation when she got the PPP loan, stolen money. She lived by the philosophy, she say, that I live by. And as long as you do what you love, the money will come. That's what she said. And I certainly do live by that. Because I guarantee you I've spent way more money. And then in business, they say it does not make sense to spend more money than you bring in. But again, this is something that I would do, and that's why I do it. Because I really would love for somebody, mainly our babies, to learn that we've been sold a lot of lies. And we're taught the lies. And our parents didn't know. And some of them could have thought because they know how they were living. And they know that they were doing the best that they could, but they could never get ahead. But when you have laws in place to keep you out of places, there's nothing you can do but be the best you that you can be in the circumstances in which you find yourself. And I suggest that everybody do that. And if you have issues, start with you. You know, I've already told y'all so many times, Michael Jackson said, I'm starting with the man in the mirror. I'm asking him to change his ways. No message could have been any clearer. And I can't remember the rest. So if you want to make the world a better place, just look in the mirror and make that change. And I think that's what he said. So you have to start with you. And in order to start with you, instead of going out, you got to start within. So you got to go deep inside of you. And then once you deal with you, you got to forgive you. Oftentimes we forgive everybody but ourselves. Yet we still have these nagging issues in our heads. And we can't understand why. And it's because we haven't done our work. We have to put in the work. Trust me, I know. Been there, done that. Sometimes you have to seek outside counsel. You got to be very careful when you pick counsel. You want somebody that's going to listen to you and give you a different way of seeing things, a different point of view. You don't want to go to someone who start out listening to you, and before you know it, you're hearing their story for that 45 minutes that they're going to give you and charge you an hour. You don't want to do that, because they will do that. You didn't come there to counsel them. You came to empty your garbage, to help yourself. And it's okay. That's one of the things we think that is not okay, but it is really okay. And then, a lot of people talk about mental illness, and my view on mental illness is totally different than most. But I truly believe that the traumas of our life, the pathology of the family, really does affect our ability to make decisions, to not procrastinate, to follow our dreams. And then some people have been so traumatized and hurt till they excel because of it. So you don't know how someone's trauma affects them. So you can't take it lightly. You just got to know that we're all human, and there's nothing that overcomes us that's not common to man, that we're not provided a way with escape. And the way with escape is to go inside and work your way out of it. He always blames the defense on everything. Oh, I wanted to show y'all that clip again. I don't know if you got to see it, Bahara. But, you were talking about that language with the finger and all that. Yeah. And it's amazing still. I see people growing exponentially, and I'm losing 1 or 2 people. I don't know if that's people really unsubscribing or if that's YouTube. But it is what it is. It goes on. It never changes. It ain't nothing I can do about it. But let me show you this. And as I stated before, the security guard or whoever, the bailiff or whatever, he was up there talking to the judge because the judge called him up there. Then he left out. Okay, may have had something to do with Mr. Copeland, may not, I don't know. But then this is him coming back in. So I want y'all to just pay attention to what you see. I'm going to play it a couple of times. I just wanted y'all to see that. Like I said, I don't know anything about any Illuminati and all of that craziness, but I do know that there is an Illuminati, and it was started by the Rothschilds, but I don't believe it's nothing that we're a part of. I can tell you that. And I do believe that there is good and evil in life, and so you're going to pick good or you're going to pick evil. It's going to be your choice. It's a right and a wrong. It's a dark and a light. So, it's your choice. It is your choice. So, I'm going to try my best to make a few little videos. Sometimes people look at them, sometimes they don't. But I will just keep putting out my work product. And you guys, I'm so glad that you stayed with me. And keep coming back. I greatly appreciate you. Life happens to us all. So every now and then there is a cycle of people. They come and they go. And that's okay. I'll be here until I don't want to do this anymore. I've been teaching and helping people my entire life. And so I will continue to do that until I don't feel that I'm helping anymore. Thank you, Regina. I will see you guys on Sunday. And y'all, if you get a chance, try to check into that trial, because there's going to be some fireworks going on. Because Mr. ruined his career. He could have left out better than this. And they may even allow him to stay. I don't believe it. I believe all these good people that got in under the affirmative action and got in that's supposed to have been helping save and change our conditions. They got in and did what the people that was there before them did. Nothing. Helped themselves. And instead of them leaving gracefully, they're all going to go out in shackles and go on to the penitentiary. Chains. So it's going to be interesting to see how all this stuff play out. But I'm going to keep watching. And I ask you all to do the same. If you don't get to look at the whole video, just go back and check it out. Spurts by spurts. I know they're relatively long. And some people don't like long videos. Believe it or not. That's what I used to look at, long videos. But a lot of people are not me. And that's okay. I just want to make sure that I do what I can to help uplift fallen humanity. Thank everybody for being here. You know I believe the children are our future. And I'm going to go out that same way. I just believe that. And I know we got to teach them the truth. And quit teaching them the falsehoods that we've been taught. Some of us just broke out of that, whatever that chain was, and decided to learn on our own. So, as they say, each one reach one, teach one. And perhaps we can make a difference. I'm leaving the Tigers dead. Goodbye. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. a lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.